Hey all, here is a replay version of the most recent live stream Q&A on all things Social Security that occurs every Wednesday at 1 p.m. Eastern Standard Time. So this is with all of little silences carved out of it. So I hope it's an easier listen for those who are doing the replay versus being there live. And we'd love to see you live. So feel free to pop in. Bye-bye now. Hello, guys. How are you? What's going on? Happy Wednesday. What do we say? Happy Hump Day. Do we still say that, or is that probably a little too old for that, right? Okay. Kevin. Hi, Kevin. Good to see you. Tennessee. Morristown, Tennessee, right, Kevin? Earth One, good to see you. Thank you. AF Vet, always good to see you, pal. Kubi Dreams, good to see you. Mike Page is in the house. Hi, Mike. Good to see you. Hey, brother. Good to see you. All right, so a lot of friendly faces here, but how about some questions? Anybody got anything exciting they want to ask about or anything of that nature? I should probably let me put something up here. See if there are any questions on the YouTube posts. Sometimes there's some there, and I do try to answer them all. I did do a bunch last night. What do we see? One of the more recent ones that I didn't respond to yet was asking about spouse with child and care benefits, and that was SZ, along with a child receiving DAC. Yeah, I don't know if he or she is here right now, but I would need to know more specifics about what you are interested in knowing about that. But another disabled adult child. This question was, I'm back at a hearing level for the new application, working on getting approved based on 12.05B listing. Conditions have worsened, no longer mentally fit. Parents are retired. Sister with Asperger's already has DAC. So when I get approved for SSI, which I applied for, is it possible to SSA? Nah, okay, I'm just going to answer that question. The person was asking about, and this is my retro, I'm presuming over the age of 22, having a hearing. I'm assuming you're not saying you're proving it before your age 22, but you're wondering if since your sister gets DAC, could you get DAC, disabled adult child benefits, since you're the sibling and you're disabled now? That would be no, unless you prove that you met the criteria and were disabled since some period before you turned 22 and it continued to the present. So if that's the case, yeah, you could get DAC as well. Depending on your age, I don't know how old you are. Sometimes when it's like 25 years later, which is not unusual, it's hard if you haven't kept all the medical records that go all the way back. I mean, I'm talking if it started in high school or before or was at birth. It's troublesome because they didn't keep records that long back then. And sometimes they still claim they don't, even though everything's digital. So go figure. So you could get DAC, but if you don't meet that burden of age 22, you'll be not able to get DAC. And you will be with the SSI, assuming you don't have your own work record, which it sounds like you don't, or else you would have mentioned that you were filing for that. Okay, let me get back to you guys, see if anyone, yeah, okay. A couple questions in there. So anyway, that was just a little extra since we didn't have any questions. Everyone was just saying hello. I see Danny's in the house too. Deanna Houston, good to see you, Deanna. I hope you're holding up there, girl. Happy Wednesday to you too. Okay, what do we got here? Let's see. It looks like this is kind of the first question. I don't think we've met. This is, am I going to, can I just call you Fun Scratcher? Z Shine Fun Scratcher. Nice to meet you. Like I said, I don't think we've met. She says, he or she says, good afternoon. How can you get your limitations into your medical records of your doctor if your doctor won't fill out the RFC form? Okay. RFC forms, most doctors aren't going to fill them out, guys. That's just the way it is. And I can't even say, that was a clunk because the tortoise just clunks back into the room. Vast majority won't fill them out. So don't take it too personally, although I would too, I suppose. And I'm sure they all have their own reasons. I know some of them can be because they recognize that they don't know what descriptors they would give and what those would mean under the SSA law. And I appreciate when they won't fill it out for that reason, although sometimes we educate them on it. And I'll get to that in a minute. But because if they say, she's moderately limited in that, and in this and in this, and that's really, moderate means kind of like, it's not mild. It's just not extreme. And for many cases, the law that applies says something different. You can't just be moderately impaired in a gazillion areas. It has to be 2 marked, and I say marked, guys. I know some people say marked. I say marked so we know for sure what we're talking about. And 1 extreme. So in some of those RFCs. And if they don't know that, they see you, I don't want to say at your best, but you actually made it to the doctor appointment and all that. So they're hesitant to say that, Maya, excuse yourself, out. So that's one reason. And I appreciate that because I don't like my client. In fact, it's kind of like a rule we have. Like, don't go and ask your doctor for a letter ad hoc if we need a letter, we're gonna seek it out. And the doctor may or may not be willing. And I'd say 90% of the time or more, they are not. Once in a blue moon, you get one that's going to try to charge the client $500. I haven't seen that in a while though. It's really ugly when they do that. The other thing is a lot of times they work for a company that prohibits it. They don't want the risk of saying something wrong, and then they just hurt their own patient who now doesn't want to come back to them, and then they just lost a paying customer. So there's, reasons like that. And then the third one might be it takes them time, and time is money, and also time when they're probably very, very busy and probably working overtime as it is. So I think those are probably the three main reasons why they don't do it. There are the ones that have, well, a bunch, like a large portion of the ones that I've seen that have, and again, you only want to ask for it when you have a reason to, they have just required that the person make an appointment so they get a paying appointment. I think that sounds kind of fair. And while they're there examining you, it's really more of a verbal discussion, and maybe they check your heart, I don't know. And that's how they get paid to do it if they're not otherwise prohibited by the enterprise they work for. So really the RFC form is not something I would expect. We don't hang our hat on that at all. That is not something that is even a twinkle in the eye. We try to build strong from the foundation without having to try to do all those begging things with a doctor who's probably going to say no anyway. And then if he does it, you don't know what he's going to say. What if he's just ticked off at people that file for SSD in general, maybe just a biased person, and decides to really go to town on, the things that would weaken any suggestion that you can't do certain work activities sufficiently to get any job. That's a risk. And that's probably the biggest one I always say to people. Don't just go and ask your doctor. And I always say, don't even tell your doctor you're filing unless you have some grand reason to know that he is highly supportive, in my opinion, because I've seen it in records where a person did that and the doctor or the MA or whoever's taking that information says, he's here to get disability benefits. It just looks very mercenary. All right. So the other way to get your limitations in your medical records is really more of a more patient durational way to do it. It's really the best way to do it. It's the most natural, and it's going to have the most clout, way more than a doctor filling out an RFC form that probably doesn't even match his records, in which case they often give it very little weight. And that would be regularly complaining to your doctor, all of them, at every visit. I know some specialists are not going to want to hear about what's over here, that's not related to what they're treating you for, but do the best you can. And definitely your PCP should be taking this information and the specialist to which it applies. So every visit, you're saying the same thing. Now, as we all know, a lot of times they don't bother putting that in your record, what you complained about, which is flabbergasting to me, because that's where their beginning of their information comes as to what's even a problem. What's actually affecting the person. So one of the ways that people can now, most people anyway, can now supplement that lack of their taking the time to actually record what you say is by sending periodic updates through the portal messaging thing for that doctor. And that's personally, I think, a really, if you've got a doctor that's not going to be properly documenting your complaints, and that's not uncommon, you guys might have seen that already, that is a way to, and I wouldn't say go in there every day. You're not trying to harass them. I would say a week or two before, or maybe the week before maybe within the week before your next appointment, to say, I just wanted to get the symptoms in here because, I know we may not have a lot of time at my visit. This is what's been going on. Don't say it's because I want you to document this in my record. You're already kind of doing that by putting a message in the portal because that's now part of your official record. Keep it short and sweet. Try not to run it through ChatGPT and look like you're a rock star, just short and sweet. Like if you have IBS and you're going to the bathroom, 3 times an hour, then that's the kind of thing, aside from having a journal, so you know exactly how often you're going and how many days a week that's happening and the duration and stuff like that, you can sum it up in the portal. Also keep the journal, because that's something else we can send in maybe every 3 months, every 6 months, whatever. But if you've been kind of reporting it before the next appointment, because you could say something like, I've been going to the bathroom quite a bit lately, so I'm not sure the medication's working. Can we definitely review this at my next appointment? You just got your evidence in there, and you got it for a good solid reason. You have an appointment coming up and you want this to be addressed. Same can be true for symptomatic back problems. Not so much the journaling, although in theory you could do that too. But if your back has been worse, or not remediated by that medicine he gave you, or the PT, or or it's been a little bit helpful with the PT, but still you're having all these problems. Not a bad thing to share. I still can't make it to my mailbox and back, doc. And so I'm hoping we can review more options to see if there's some other conservative therapies or am I only looking at surgery or, but throwing out the questions, not telling the doctor the answer because that's his decision about what he would recommend. But you can throw out things that you know exist in terms of conservative therapies and say, do you think this would work? Can we talk about this at my next appointment? And then the other time is sometimes the appointments are really far in between, like let's say it's 4 months. And that would not be that abnormal for a specialist appointment or when there's just a chronic problem. Sometimes smack in the middle, just throw it in there, like just keeping you updated in my file. So when I do have my next appointment, doc, what's been going on. I'm journaling it a bit, but as of now, this is how it's going. Obviously, if you're doing super well, you probably don't want to message that. What was the other thing about that I wanted to say? Something about the messaging. I can't think of it. But those are the ways I think it's best to get your limitations into the medical record, because then it's probably going to be talked about, and then he's going to actually write it too. And now you've got it in there twice, because what the SSA needs to see is not a snapshot once a year that you complain about something, but if that's got a continuum, because remember, there's a 12-month durational requirement for all cases. So something to think about. All right. Kevin's reminding us, what can I say? I prevailed already. Yes, he did. We love that he comes back and shares that positivity and says hello. You can still ask questions, Kevin, though. Things come up post award. YouTube 1970 says, good afternoon. Good afternoon to you, too. Now we have Paul Resendez. Hi, Paul. I don't think we've met. Nice to meet you. Thanks for showing up. Hello from California. Great channel. Thank you very much, Paul. Question. I have been on this SSDI journey for 408 days now. Yeah, over a year. Oh, well over a year. A year and a few months. DDS said they sent the file back to the SSA in quality review. Is this normal? Yes, when they make a determination, and I don't know if you're on initial or recon. It sounds like you're on initial, or maybe you would have mentioned that, but it doesn't even matter. So DDS, whatever round you're in, made a determination and sent it back to the SSA. The SSA didn't act on it, whether it's a denial letter or an award letter, because quality review picked it up to audit it, so to speak. And it is normal. It's not every case though. It's a random audit, I believe. And generally speaking, with some rarer exceptions, and I know so because one or two people in here over the last year have said they got denied after a quality review. But I find that by and large, the quality review, it's there to confirm that the adjudicator followed all the steps in their little listing of things to do. It's very regimented. Well, the sequential evaluation process that they have to follow is carved in stone. That's the rules. But and that applies even with an ALJ. But I have a feeling that the adjudicators have a little more checkbox type of, in order to deviate out. I just don't get the sense that they have the power or authority to do as much reading between the lines and using extraneous common sense things that a judge has. Just my perception. Once we get Judge John on here, I can't wait. We can see what he says about that. Okay. If he, he was on the judge side. I don't know if he was on the DDS side before that. So yeah, I think that's normal. And I think usually it turns out well for you. So fingers crossed for your Paul. Okay. And if it doesn't and it slides sideways, just do what you have to do. If it slides sideways, that means you'd get a denial, right? And we never know for sure. Did the DDS guy deny it? Quality review took it. Quality review agreed with him that it's a denial and sent it on its way. That could be. I had a case that was denied. Literally, we got the notice that it was denied, and then we got a notice that it was flipped like a month later. His quality review somehow picked it up and flipped it, and it was almost like a miracle. It was an SSI young person, and we had already done an entire case through hearing over the few years before. And I just don't drop my people when they're trying hard and they're largely following the legal advice. So this guy had to get to win at some point. So they can do that. I just don't see it much. Now, I do know also you can't see it from your side unless you order your file. So let's say at whatever point, if you lose and you have to appeal, you want to order your file anyway from the SSA using that 3288 form, usually. You want your whole file. In there, like for this one that I've had a couple now, that I've had one that was awarded but with a more recent date. This is all in the last month or two. And the quality review took it and they said, we agree it's an award, but you got to go back another 6 months. So they gave the guy they got him back to the alleged onset date we said, instead of the later one that the adjudicator had put on it. So that was kind of interesting. And the only way I knew what was going on. I could read it because there was a DDE that gave one. DDE is disability determination explanation. They don't send that to you, but it's in the electronic file, and we get access to that. And you can get it from the SSA. I don't know why they don't. It should be in your stuff too, but it's not. In fact, we only got it very recently, like I want to say 2025, when they started. SSA took a different stance about letting us representatives, at least, see more of our client's file. It is kind of like a due process thing, I think. So that was great. So I could see awarded at this date, which I was still thrilled about. You know, this whole thing is very stressful. You guys all know, and I just love it when like my people couldn't win earlier, but sometimes they do end up giving up some back benefits. And then I saw the next DD, so I'm like, why is there two? It was fantastic. So it's usually good, Paul. Hey, Kitslots is here. I love your name. Cracks me up. From Punta Gorda, Florida. Oh, you're not the other person with a different name from Punta Gorda, Florida, are you? That's funny that you would have switched your name, so maybe not. Maybe you're just also from Punta Gorda, Florida. We have another fairly regular person. Now that he's prevailed, he's less regular, which is all good. He's going on with his life, which is superb. So hello to you, shit slots. That's such a juvenile sense of humor. YouTube 1970 says, SSA notified me today my case had been redirected from Orlando, Florida, where I live, to New York. I'm 56. It's probably, well, did they say, they didn't say they made a decision, right, YouTube? I think probably it's an overload, like work, they supplement the work process to help a busy office. Could be. Unless you were still at the SSA level and certain age groups, and I don't follow, their little nuances with this. But certain ages are sometimes put to a different office, and it would be the older ones. And you're younger than me, but you're still getting up there, pal. So that could be. But either way, that's not a bad thing. And that's assuming you're still being determined. If not, that could be like going to a payment office for that aspect. That would be nice. Hey, our Willie's in the house. Hi, our Willie. Happy August already. I know. YouTube says I'm in initial stage with an attorney. All right, awesome. So I think that's probably what it is either that age-related office that handles all those. I don't know what particularly is the reason why, but it could be that, hey, all the 55 and aboves, these are the only rules that are going to apply to them. So let's just do them all here. You know what I'm saying? And then, or it could be just workflow overflow, being handled by the overflow office or one of them. And we've seen this everywhere. I have people with hearings where it's you're in this territory and it used to be in person, you're always going to get a judge from that area. And that was kind of the rules too. And if you they moved it to your new territory and got a judge there. But now with everything online and on the phone, I don't know that I see that all the time. And there's also a national office where they have cases, they pick up cases too. So I had a case recently that was, let's say, out of DC, and the person's like, I forget what state, but definitely not DC. So, they move it around so everything keeps flowing, you know what I mean? La Rocha's in the house. Hello, Miss Stephanie. I'm in the All Things Social Security Live this lovely afternoon. Yes, you are. Nice to see you again, Lily. She says, don't forget to like, subscribe, and share. Well, that's super sweet. I couldn't agree more. Our Willie says, was just notified that my federal appeal is getting a voluntary remand for a new hearing. That's awesome. Can't wait to tell your new attorney. I have a feeling she knows. But if she does, probably just now. DJ says, hi, DJ. How are you? Hi, thanks for being here. I was denied, as you found out yesterday. Yeah, I'm sorry. I wasn't, for some reason, I don't know. I was forgetting your history because, remembering everybody on here when they're not my clients, it's difficult. No sleep for 3 days. I'm spent. Need to appeal. My lawyer's partner said they are no longer taking appeals at this time. So, DJ, you were denied by ALJ, I assume. So those guys don't do appeals, counsel appeals. Yeah, a meeting. Okay, then he says, I'm meeting with another next week for 30-minute consultation, see where it goes. DJ says, ALJ mostly found some notes or records from doctors that didn't state I was as bad as I shared in his opinion. There's various reasons he decided what he decided. You're very gracious, and you're not wrong. I just know some people are a little bit more, reactive when they get a denial. Because people are having a hard time paying bills. DJ, I feel like did we talk about this before? I don't recall your category, but if you want them to see if it's got an opening with us, you could do that. I'm really sorry. I know you're down and out about this. I can't guarantee it though, because did we look at it before and did we look at it before? And was it not a category? Was it a category that was waitlisted? Or did we never because you had an attorney? I don't remember. And then I hadn't seen you in probably a few months, right? But I'm really sorry about the results of that. Fun Scratcher says, my PCP tells me the specialist is supposed to record my limitations, problems. It's true. And then my specialist says my PCP is supposed to do it. You know, they're both supposed to do it. Now I could understand the PCP. I'm sorry, not the PCP. He should be writing down everything because he covers your entire everything, your whole body. You know, if you have a knee specialist, he's probably not going to want to talk about your mental health or, you know, your cardio because that's not his specialty. But so I'm going to go with the specialist on this one. But the specialist should definitely be recording everything about the knee complaints, assuming that was, you know, whatever your specialist is for. That's my opinion. I don't know that anyone could really dispute it. It just seems kind of medically logical. And again, they can't stop you from sending a message in the portal. Just don't make it worthless by sending it every day. Do it. And again, your specialist. So let's say you have a bad knee and he treats you for the knee, but not the hip. But a bad knee can sometimes then cause a complaint with the hip. So, you know, we're like overcompensating on one side or whatever. So I don't know that there's a problem telling your knee doctor that I still got the limp and now my hip is hurting me. You know, maybe he does hips too, or maybe he has a colleague who looks at hips. But either way, you're getting it in there. And that's really the basic point is that you're complaining about it. That's what we're kind of looking for. Like 18 months later, when it goes to a judge and he sees that you've been complaining this whole time, I promise you I've seen in many denials where they say, but we don't even see a complaint about this for 13 months. So I can't really find that to be as limiting for, the 12-month duration or not being improved for 13 months, which would then defeat that being part of the disability picture. So that's why I'm like, at least they can never say you weren't complaining about it. It's not going to be the same evidence as an MRI. And you guys know I babble all the time. Get those updates. If it's musculoskeletal MRIs, they probably will start you on an x-ray, but I wouldn't stop there. And that would be a squeaky wheel. And you're the only person that can do it for you. They sometimes don't even mention it. And you have like a bad back. And they're like, well, here's some oxycodone. That's not going to be enough evidence. The MRI will show what might be going on. And don't think it has to be from an acute injury at all. It doesn't have to be work-related. In fact, it's better than not, in my opinion. It's degeneration as we get older. And that counts. It doesn't count for other things. It doesn't count for personal injury, perhaps. It doesn't count for workers' comp, for sure. But it counts for Social Security disability every day of the week. So those degenerative things that you're like, oh, my God, my shoulder down. It doesn't have to be the thing that took you out of work. But always look at your body in full. And I use a body chart for this. And go through all the parts. Is everything as good as it was when I was 20? And I'm throwing that out there. If you were disabled before 20, then you're going to have to say something different. But just for the general population, which part is not, and as good as it was when we were 20, that would be degeneration and or everything else that this happened to it. Keep in mind, when they ask you about, if you can lift 25 pounds, or I should say this in a different way, in a kind of esoteric kind of way, the presumption is, entering into the whole case, you are copacetic, no impairments, no limitations. You could do that for 8 hours a day. You could walk for 8 hours a day. You could sit at a desk for 8 hours. You could sit at a desk for 8 hours a day. You could talk to the public for 8 hours a day. You could lift, in theory, 100 pounds 8 hours a day. Although I had seen common sense judges say, the lady is 52 and 89 pounds. And even if these were mild impairments, she certainly can't be. Why they put her at heavy? She could do heavy. I remember that case. It was pretty funny. It's like, yeah, I don't think she could be lifting 100 pounds, which is more than her own weight, 8 hours a day. Crazy. But that's what you're so you got to remember, they get you as a perfectly super fit Superman, Superwoman, and you got to start nicking that down. And always knowing what the law you have to meet is invaluable, because what's the chance you're going to just by accident have those medical records connect those dots to that little, there's like 3 spots up here you have to get in the whole. It's like throwing a pin in the tail on a donkey. Pinning a tail on the donkey, trying to get his rear blindfolded and not seeing him in advance. I mean, it's just crazy. All right, DJ. I met all non-medical requirements. Yes, of course, we tend to do that. He was lead judge with 62% approval rating. The hearing went well. I'm shocked, but need to appeal and move forward. I appreciate your attitude, and that is the attitude to have. How's your DLI doing, DJ? Unless this is just an SSI case. How was your DLI, date last insured? That would be my biggest worry with you right now. Unless you've been doing that part-time work we talked about to keep that DLI forever in the future. Candy Brown says, hello, Candy. I think we met recently. Hello, I had my ALJ hearing 7/30/26. Thank you, very recently. Vocational expert was on audio call. They typically are on audio, not video. along with my attorney, so he was on audio also. 2 hypotheticals, asked no to both. That's awesome. Lasted about 30 minutes. My attorney said it went well. That sounds like it went well. If that vocational expert to all questions posed never presented said a person with the RFC presented by the judge could not do your prior work, and also says that's assuming you have prior work in the last 5 years, and also says no to all the other hypotheticals. But is there any other job he or she Candy can do? And that does sound very positive. So fingers crossed for you, Candy. I'm glad you got through it. Stressful, right? Hey, Rain Gal's in the house. Hello from Tacoma, Washington. Hello there, Rain Gal. How's Tacoma? Is that rainy out there a lot? Or is that just Seattle? Okay, YouTube says he's in the initial stage. Okay. Shitslots says, yes, it's George. Oh, George. So there's only one Punta Gorda in the room. That's funny. I appreciate you too. That's too funny. I didn't want to say the name out loud in case it wasn't you. You know. Shitslots. So we know a you on your case under, don't we? Just kidding. That whole IBS example I gave, was that about you? No. Kidding. You too. You're welcome, you too. Hey, David's in the house. David, I don't think we've met, have we? Your name wouldn't be one that would stand out. During a hearing, how do hypothetical questions work? What is the judge asking during this phase? Okay, so after all the evidence has been presented, you've done your spiel, answered the questions, or presented your own statements about your limitations and symptoms and stuff like that stem from your impairments, and all work questions have been resolved. Then the VE is the one on the stand, and he or she usually will categorize any prior work you had. Did you have prior work in the last 5 years that has to be considered or no? And if you did one job or more than one job, the VE will have it categorized. The exertional level, the skill level of that job, and things of that nature. Okay, the RFC basically. And once your past relevant work is done, then the judge gives the VE the first hypothetical. Sometimes there's one hypothetical. I've seen 7. It can vary. I'm sure there's been ones with more, maybe. That one was pretty long. It's kind of incredible. And so the judge, creates an RFC that he thinks might be, possibly is, what he would find after re-reviewing the medical records after all your testimony and the hearing's over. So he'll put up that RFC, meaning if a person of the same age, experience, and education as David, who is limited to light work, meaning light exertional, you guys all know how that's defined, right? That's the one that's up to 20 pounds of lifting, at least occasionally, and 10 pounds frequently. Occasionally is 1/3 of the day, frequently is 2/3 of the day. And light also includes the ability to be on your feet. So you can't, if you're relegated to sitting most of the day, you're not capable of doing light work. You'd be sedentary. So he'll throw out the exertional, and then he'll say, and additionally, he has these further limitations. He can only use his right arm frequently, not constantly. Because remember, it could be constant, frequent, occasional, or not at all, basically. But they don't really ever seem to say that. So he'll give them whatever's in your, like whatever he's picking out from your file. Usually it's the serious stuff you put out there that you claimed and there was evidence to back it up. Now, in my opinion, they often go a little overestimation when they give the hypothetical. Like a person with significant rheumatoid arthritis in their hands, I'll see them all the time say, limited to frequently. She can't do constant hand use with her job. The job can't require constant hand use, but frequent's okay. I'm like, who can do 6 to 8 hours with their hands if they have hand rheumatoid arthritis symptoms? It just doesn't make sense. So, or whatever it is. It could be osteoarthritis. But I do see that a lot. That's one of my biggest gripes, is that they underplay hand limitations. Because if they said occasional, those jobs, they know that it nicks out a ton of sedentary jobs. Ton. Just think about it. Sedentary jobs. Desk doing this. It could be small assembly work in a factory where you could be sitting and putting together these little tiny things. So they don't want to get rid of that. So they'll put it frequently. And it bugs me to no end. And I almost always bring it up at a hearing because it really ticks me off. But anyway, they'll get through all the limitations of the hypothetical person that may later be attributed to, yes, David fits this hypothetical person. And then depending on what the VE said, yes, there are jobs here that hypothetical person can do. And he usually has to list 3, or no, there's no jobs, or there's only 1 or 2. Then there's a more kind of esoteric question of, well, the job numbers that he has to give for each of those jobs that the hypothetical person can do, are those significant in the economy? meaning do the jobs exist? Not whether there's openings or anything like that, but do the positions exist in substantial numbers? We don't have any kind of bright line rule on what is substantial. I was always under the impression that a few thousand certainly wouldn't be. Although I just had a judge say that I can't remember the job. I'm sorry to say, I'd have to go re-listen to the audio, but at 21,000, since it was the only job, maybe that's why, was not substantial. So that wasn't going to be counted as something the person could do. Anyway, so then if the VE at the end of that hypothetical, David, says, yeah, there's these jobs, then if you're your own attorney, it's your job. The judge will maybe give him another hypothetical. He might change it from light to sedentary. He might keep it at light, but then add more manipulative limitations, a difference there. Like maybe he'll go from frequently with the hands to occasional. It could be he, whatever he's going to throw in as an additional limitation that he thinks the record might support when he reviews it all again later with the testimony. And then that usually it either will have additional, other jobs that could be done with that more limited RFC or not, or no jobs. And sometimes they'll do the hypothetical addition. All right, for any of those jobs you mentioned above, Mr. VE, if a person is going to be off task 20% of the day due to medical symptoms, pain, mental distraction, whatever, would those jobs still be performable satisfactorily by that hypothetical person? And you're going to hear a no. So he just left a hypothetical at the bottom, about the off taskness, that if he decides you would be off task for 20% of the workday outside of normal breaks, he would find you disabled. But don't count on him to necessarily do that. A lot of times they ask the question because they know if there's an attorney on board, the attorney's going to definitely put that in there. So some judges go ahead and do it themselves. I'd say it's like 50-50. But I always do if they don't do it, of course. And also absenteeism. There's a limit to how much a new worker can be absent and not get canned. So usually I pose it as asking the VE his opinion on what that number is. What is the standard in your opinion of acceptable absenteeism? And I usually hear 1 day a month. Years ago, 5, 6, 7 years ago, I used to hear 2 to 3. I remember one VE said 3. You could just be out 3 days every month as a new worker and not get yourself canned. I said, really? I said, so 3 times 12. That's 36 days, 6 days a year, huh? Is that right? Huh. Which jobs would that be? I want to go get it, Like, it's just ridiculous. Like, that's so false. I don't know any employer besides like Uncle Johnny that hires, the nephew or the niece that would tolerate it. So they're kind of getting away from that. And I really have not heard that kind of silliness in a while. Anyway, how's that for hypotheticals? You want no matter what, even if it has to be you doing it or your attorney, to get to a hypothetical that has 0 jobs, that those limitations that you add in, you believe are substantially established in the medical record, in this section F, guys, if you're looking at your own file. And that doesn't mean the judge is going to take your hypothetical, though. Of course not. He's probably going to take one of his own. But you're kind of lining it up, knowing he's going to do that. Sometimes you put it in there for appealing purposes. And it doesn't change it doesn't necessarily affect whether you're going to get the remand or not. Because if they think he followed all the steps that he needed to legally follow to come to his conclusion, he didn't have to find that you would be absentee, that many days that you believe you would. So there's quite a bit of discretion there. The more evidence you can get of absenteeism is awesome. Let me just toss this out there, guys. If you can get your old attendance records, like at your last job, and maybe that was like a year ago and then you filed, or that your alleged onset date is the day after that job, and you were having bad attendance, and the writing was on the wall, or you got fired for it, you might have left because you're like, this is ridiculous and I can't do it anymore. You can get the personnel record that shows which days you are out, the attendance overall. And then usually the pay stubs will sometimes say of every paycheck which ones were paid under sick time that you had. And then if you had to go on FMLA, more time off, or unapproved, which is when you're going to probably get canned eventually. So definitely something to dig up if you have that. You can go around it. That's very objective. It's already showing that you already had an absenteeism problem. So it's not you just saying it to the judge today. You would have already sent it to him. Like, absenteeism was a big problem, and I'm not better than I was, Kathy Clayton's in the house. Hi, Kathy. Happy Wednesday. David says, had a remanded hearing this morning from Appeals Council. So the Appeals Council had remanded it already, and then you had that second hearing with the same judge probably, right, David? Unless sometimes it'll be a different judge, but it's supposed to be with the same judge, unless there's something barring that. least for the first one. So what happened with your hypotheticals then, David? Since you had your hearing, did it happen that way? Or did the judge not ask any, which can be very good because he doesn't even need it? I would think that tends to mean a listing, but so we're dying to know, David. DJ says cervical osteoarthritis, bone spurs, diagnosed fibromyalgia, etc. It was my judge after hearing denied. I get it. How old are you, DJ? Happy Clayton says I was approved yesterday, fully favorable by the attorney decision writer. So that was an OTR. Wanted to thank you for all your wonderful videos. Thank you, Kathy. Kathy, I'm so happy for you. Yeah, thanks for being such a steady presence here. I'm very super happy for you. So attorney decision writer. Now, of course, all the judges' decisions are written by the decision writers. However, I'm wondering if you're saying, I don't recall, had you gone to a hearing or was this an OTR on the record review with an award? Because they looked at the record and said, we don't need the hearing. This is clear. I love those. We just got one of those ourselves for a hearing that was scheduled. Well, I think I told you guys this the other week. Scheduled for May, gets canceled 2 weeks or 3 weeks before the hearing. My client is devastated. It's been a long road for her. She had a case before I even became involved, but she lost. So it's been 8 years or something, and they moved it to, by the time they rescheduled it, it was moved to October. So we're like, okay, so, and this is with a remote DLI. It's one of those cases that are kind of hard to get a lawyer on. And then I get a notice that they canceled the October one, and it needs to be postponed. So I spoke to them. I said, can you, we'll waive the 75-day notice. Can you get this in without much ado by, since it was October, we don't want to go much longer. Well, they not only did they do that, they got it in August. So we got a quicker one. And then 2 weeks beforehand, you get a call saying, would your client amend the onset to 55th birthday, which barely loses anything. Maybe, well, it could have been a year or half a year of benefits. And this person is now that's like four years of benefits still getting. So back pay, which person could really use. It's been a very rough economic time for her. So very excited about that. So right now we're in the post-hearing, post-award, situation. And this is something to be alerted to too, guys. When you apply, when they say, are you or will you or could you be getting workers' comp or public disability benefits, that doesn't mean you're going to be applying for SSI. That's a separate question. Something else, if you don't have workers' comp, just because you think my work really caused me to have all this stress, and therefore, if you don't have a workers' comp claim and workers' comp would never accept it, and you never even pushed it, and or they denied it, and you never pursued, don't say it's work related, because that's your subjective feelings. I hated my job and it made me miserable and made me sick. Okay, and don't get me wrong, it could be true. I know that for a fact. But if you do, you're going to have the situation that we have now, where they're saying, all right, so in order to pay this person, we need to know all the workers' comp she got and when, because we have to check for the 80% rule offset. And I'm like, workers' comp? Because I didn't file the original claim. Even on this one, I came in like a week later, or 2 weeks later. And so I just confirmed there's no workers' comp here. It's totally not an element that would be workers' comp anyway. And the answer is no. So I think there was just confusion when she filed. Maybe she was thinking public disability benefits, SSD. But that's, anyway, so we have to prepare a statement for her that there's no workers' comp. That was a mistake. Never had it. Don't get it. No public disability benefits. No. Because I've had SSA offices say, well, you have to prove that you're not getting it. How do you prove a negative? How do you do that? Do you write to every workers' comp insurance company in the world and say, could you please do us a favor and confirm that this person you've never paid him? I mean, it's ludicrous. So I'm trying to divert that from happening by having a certified statement from her, saying, no, I've never had workers' comp. And the other thing we can do, although I don't know that it would really work, but although I use it all the time when I do know the employer, well, we do know the employer here, but there's no past relevant work, so there really is no employer. Something called the SSA 1709, when you can't get any records because you're like, I don't even have any, and my attorney doesn't talk to me, or I didn't have an attorney. Let's say you did have workers' comp or did not. I would fill out the SSA 1709 that gives the SSA, it's their own form, permission to go seek out the labor department and find out if there's been a workers' comp claim, because all those workers' comp claims are, registered, if you will, with, I think, the Department of Labor. So it's like, come on, SSA, you guys got your fingers in everything. You can touch, you can go in there, and I'm giving you a release. You'll find what you want, because I'm telling you right now, there's nothing, and I can't prove a negative because you're not listening. Yeah, it gets me really hot and bothered. Can you tell? It's very aggravating when they do that. DJ says also bad constipation and general anxiety disorder, GAD, depression are overlapping. Yeah, I know. I want to know what your age is there, DJ. Refresh me. YouTube's giving some positives. That's nice. I love it when you guys do that. Paul says, thank you. I appreciate what you're doing for us. Have a blessed day. You too, Paul. Thank you for that. That's very kind. Fun Scratcher says, I'll be 45 in November. My limitations are weakness, pain, numbness in arms and legs, etc. Sitting, standing, walking limitations, prescribed walker, and scheduled for injections and surgery. You know what? The biggest thing that points out to me here, Fun Scratcher, is the prescribed walker. Now, if they say you need a walker when you're going to walk a mile, oops, hi Tosh, going to see Tasha back there. Hi Tosh. If someone's prescribed a walker because they need it for basic walking, not just, well, if you're going to go to the airport in Chicago, O'Hare, because I think that's really big, right? Well, they're all big, but if I recall, the time I was there, it was like, it just seemed really long, like a mile. It probably wasn't, but I had at the time, she was like 70, 72 years old, mom. And I'm like, Mom, we got to run to catch our flight. Prescribed walker. That could be a big thing if you need it for all walking, because then even a sedentary job, they say sedentary, you need to be able to, it allows for, and you need to be able to sit for 6 hours out of 8 hours. The other 2 hours, they say 1 to 2 hours of every sedentary job, you have to get up. Maybe you have to go to your supervisor's office, or you have to do this. You certainly have to go to the potty, and that's why it's a 6-hour thing and not the full 8 sitting. So if you need a walker to do that, first of all, it's going to eliminate any job that you need, like even a cane, they will say that with a cane, you can still do an office job because you can use the other hand to bring a folder over or something. And, that's the argument on that. But with a walker, you don't have that one arm. And then the question is, with the walker, are you still weak? Is it the sit down kind so you can turn around and sit? Because you couldn't really go more than 50 feet with the walker, and you can't do it, repeatedly throughout the day. So the extent to which you use and need that prescribed walker, I think is really important. It would be nice if the doctor expressed how much they expect that you would need to use it. I know that might not be hard, might not be easy for them to say, but you can always describe to them in a portal message, maybe. I would do it verbally too. Like, don't negate the verbal connection with your doctor just because you also like to put a confirming note in the portal. Oh, I love that song. That would help if you're not using it just here and there, or when you have a flare up of something, which could be every few months, which isn't going to really hold as much water. That prescribed walker can speak a lot of volumes. Injections are good because they are definitely indicative of significant pain. And of course, surgery is, the king of it all in certain ways. But sometimes we're not really good candidates for surgery, or we've had surgery and it failed, and we don't think our body is going to be amenable the second time when the discs did not do it the first time. DJ says, DLI good, I said good. Sadly, he used my part-time job as proof I can do new jobs. Well, part-time does not mean proof of full-time, so I suspect he didn't word it that way because I assume it was different than my past work. Was it skilled or unskilled? Yeah, I can't know anything without seeing it. I've never had a case denied because of part-time work, under SGA. This never happens. So I don't think that would have happened. There must have been something lacking in your evidence, to show the severity. I mean, obviously, if you're doing job as a construction laborer, making, what did you say, $900 a month, that would belie the, back problems, all that kind of stuff. The mental health stuff you mentioned, that can help. That can prevent full-time work while not preventing part-time, but it still doesn't mean you can do full-time work, and that's what they're tasked with determining that you could do. So, I would get into the weeds a little bit about what those medical records said, and really cross-check, I'm glad your DLI is good. Fun Scratcher says positive findings in EMG, CAT scan, and MRI. And that's critical. How positive are they, right? A little bit of narrowing is not going to say too much. It depends what, how. It's good because it's objective. But then it's like, okay, so what does it signify? Mild positivity or severe positivity? Raingal says a lot less rainy than, because that's right, your nickname is Raingal. A lot less rainy than typical lately. That's nice. Right now, the wildfire smoke is hitting folks with asthma hard. My neighbor isn't even going outside unless she absolutely has to. Is that the wildfires from Canada, by chance? I'm here in, I guess this is Northeast PA, but so we're way south of the border, and we had 2 really smoky days down here, which I'm sure, I know it's from Canada, which that's not that typical. I don't see that a lot. My sister lives in Minnesota. I think they see it more because they're so much more north. Kathy says, letter said attorney advisor. Yeah, Kathy, did you have the hearing, or was that for your hearing? Did you answer that question? Did we go over that? Like it wasn't an OTR? Kevin says, my hearing lasted 5 minutes. ALJ asked me, can I walk or stand for 8 hours? Then gritted me at age 60. For the record, my hearing was solid gold. I go to PCP and specialists every chance I get. His diary date is 5 to 7 years. That means medical improvement not expected. So he doesn't get a CDR for 5 to 7 years. And by then, dear Kevin will be gracing the doorsteps to retirement and won't be on disability very long anyway. So anyway, that's awesome, Kevin. Yeah, Kevin's pointing out that I'll be 67 when I get a CDR. You won't get it. I mean, you're just gonna roll it through. Marcus is in the house. Hi, Marcus. Have we met? I don't think we did. I know a few Marcuses though. Question: what is the rules for a left frontal extraaxial mass? I just had an MRI. There's no rules on that. I just had an MRI on July 9th, 2026. And last Thursday, I found out that the neurologist found it, and I already have PTSD anxiety. There are no rules. You either can work or you can't work. So, what are the symptoms that are caused by that? Was there symptoms, and that's why you had the test done, and now they see the cause of the symptoms? And what are those symptoms? If the symptoms say I can't run the 26-mile marathon anymore like I do every year, because it'll start to hurt after like mile 14, that's probably not going to be enough. I'm being funny, but I'm just saying, like, it's your symptoms and the functioning limitations that stem from the impairments. You proved you have an impairment, which is a mass on your, left frontal extraaxial. But what is the symptom? And where does it interfere with work-related tasks? So that's just standard what every case has to determine. So that's not just yours. And it all depends on what's showing up, what are the symptoms that you complain about to your doctor? Did he record them in the record? Has this been consistently recorded? Has it lasted 12 months? Or is it expected to last 12 months? So all those kind of things, each and every single one. And of course, something's always changing in there, right? And the rules also depend upon your vocational profile, age, education, experience. So age being the most critical factor to start with. Chell says, hi, Chell, I don't think we met. Looks like you're water skiing. It's very nice. I haven't done that since I was very young. I need a consultation I can pay for. The assigned firm's legal rep says no function report advice going to be given. That means I don't want to. Got denied, but you discuss it. I want you to feel incomplete based on your videos. Incompetent. Wow. See, I can't stand it when they say legal rep. Are they lawyers, non-lawyers? I mean, not that defines whether they're good or not, by all means. We've got some really bad lawyers. We've got some really bad non-attorney reps. We've got some really good ones on both sides. It really depends on intention. It's all their choice, really. So, yeah, just I should put it in there. If you go to the website, I'm just going to get you the link. This is where you can go for possible consultation. Oops. It's going to be in the comments, guys. Is the assigned firm someone that you got assigned to by, say, your insurance company or something like that? But anyway, consultation is there. You'll see on that page, well, up on the upper left of that page, you'd see a link for representation if that was something you needed to consider and you wanted us to consider whether we have an opening in your category. But I'm sorry that you went with a company outfit like that. That's ridiculous. David has a different judge. Oh, you had a different judge on remand, right? You said you were in it. Had 5 hypotheticals, no one with no 1 3. I don't want that. I don't know what you mean by that. No 1 3. I don't know what that means. With no 1 3 of them. No one. I mean, it sounds like you had 3 possible jobs, or do you mean none of them had 3 jobs offered? Right? I'm not sure what you mean. I think that's what you mean. None of them had the availability of 3 jobs that the VE can come up with. Huh. I'm going to call you, I don't know what. We'll call you yes. Okay? Very long. Good morning, my friends. God bless you all. That's wonderful. I'll help you place this money used to do my dream. Help me. Okay, I can't. I'm here to answer questions. So if you have a question, yes, that's what I'm here for. So I will definitely answer if it's answerable. DJ says he's 53. It was on my birthday, July 2nd, and onset date is 2023. What is your DLI, DJ? You would have really hyped, just so you guys can understand what he's saying. So DJ got denied, which is very unfortunate, and I'm so sorry about that. DJ's 53. DJ is subject to the rule that says if you can do light work, this is for the grids. The grids won't apply to win you out if you can do light work. He had to prove that he was limited to sedentary and no more than sedentary work. It is a high bar too, and they don't dole it out like candy. What is your DLI, DJ? Can you tell me that? July 1st of 2023. Does that mean you worked through June of 2023? If you've been working steady until then, even if part-time, but steady, your DLI is probably end of 2028. So you still have time, notwithstanding the appeal and such, at least you have something beyond that if you needed it. But the 50 to 54 range, which is better than being under 50 in terms of the laws that apply, is still not, you have to be very proactive on your case. If you just think, well, the doctor didn't tell me to do that, so I didn't do anything about it. Nope, I didn't ask. The doctor would have told me. That is probably most likely not going to work out too well for you. It's never easy, even with 55 and over. You got to still meet those 3 proms through all the proofs. But 50 to 54 is much more difficult than 55 to 60. It's easier than under 50, though. I'm not saying you did that, DJ. You seem very diligent. They do have it's forever been, they're trying to avoid paying out to the 50 to 54-year-olds unless you have really, really, really clear evidence that they can do no more than sedentary. And if they already had a sedentary job and they're saying they can only do sedentary, they might still be able to do their old job. There's that too. Kathy says, no hearing, it was OTR. Yeah, when you said it came from an attorney advisor, that's what I would think, OTR. I love those. Those are the best, right? It's just it's so great. Your hearing was on your birthday? Happy belated birthday, Deej. LaRocho says, by the way, guys, we're 1 hour and 7 minutes in, just so you know. I'm losing my voice. LaRocha says, I had my hearing with the ALJ on Friday afternoon, and he mentioned that he could find approval from July 2023. I may not like it since I applied a few years ago. He said you could have an attorney. So he's saying when he thinks the evidence is strong enough for you to win is July 2023, and you are insured in July of 2023. So he's saying he'll grant you if you give him July. So did you amend your onset date? What happened? Inquiring minds want to know. Typically, I would think he said he would. Was it an evidence thing or was it a birthday change? Either way, just remember, the judge is saying, in his opinion or her opinion, the evidence matched up with the rules meets disabled in July of 2023, but not before it. You could say, well, I'm not going to agree with that. I'd rather just not be awarded and I'll appeal. Could be. Or if he's going to do the solid, you don't have to amend your onset date to agree with him. He's not going to give you a fully favorable. If he's being solid, he would give you a partially favorable with the July of 2023 onset date. And then it's up to you whether you got the cojones to go and appeal it, knowing that they can reverse the whole thing, then you could be squat out. But it's something you really need to make sure you know. You have an attorney, I think, right? So here, you said you don't have, you said you did. So what did you do? Did you not have the hearing or did you have the hearing? July of 2023, that's 2.5 years of back benefits. Think long and hard about whether you want to continue the process and go another year or two or, whatever, because you'll have to, that's if you're appealing it. Now, if he does the solid and awards what he's suggesting he's finding, even if you don't agree, then he can't give you a fully favorable, a partially favorable. You can appeal the partially favorable and you will still continue to get your benefits that he awarded you, even though you're appealing the onset. But you do have the risk of it, Chances of that are slim if you're over 55, but just saying. You could risk it. It's just do you really want to be living with it much longer, It's stressful, and it means you got to be really diligent with those medical treatments and all that. Something to think about, but I'm curious, did you amend your onset to what he said? Did he ask you to? Or what happened? I assume you don't have a result now, whatever you did. Fun scratches an ambulatory gait. That's the walker? You prescribed it because I had fallen twice due to weakness. Yeah. So you use it whenever you're walking. Do you maybe not? I don't think it's fair to say someone has to use it every second in their house. If you have furniture, that seems to me like not a bad thing. But even with the walker, are you subject to weakness? Maybe you haven't fallen yet, but does your legs still get weak because you're still holding up your body, just a little less so because of your arms, right? Just wondering. Lily says, reference above, you could have an attorney call me to request what you would like. So did you have your hearing? Did he take your full-blown testimony? Or did he present this right up front to see if he had to bother? So did you literally cancel your hearing and postpone it because you didn't like what he offered? And you could have said, no, I don't want to wait and get another attorney. I just want to push the hearing forward, but I'm not agreeing to any earlier date. You could have said that. And then he would have taken testimony then, and then he probably would have given you the partially favorable, the one you don't like. And then it would be on you to appeal it. But you at least have those. I'm curious what an attorney will tell you when the time comes. Will they say, well, because it's always up to you. But will they be like, I'm not really comfortable taking this to a judge when we already know what he thinks. Unless Lily, is there missing evidence in your file that would point more strongly to before July of 2023? I don't know what date you applied and said you were disabled as of. I don't know. You know what I mean? If there was missing evidence that the judge didn't get to see, because he doesn't agree with you, and he's looking at the records and he's very experienced, he or she. So just want to. Phone scratcher says yes, it's a rollator walker, and he does not state he does not state in the chart the reason for it. I mean, the reason for a walker generally is because you need it to walk. So that's already like a given. And if it's prescribed, as opposed to you just deciding you needed one and going to a used, finding one in the thrift and using it, which does not make it medically necessary, it's got to be prescribed. At the very least, there's got to be a lot of rhetoric in the regulator. Urge her to get a walker. And if someone ever does that, if a doctor ever does say get a cane, ask them to prescribe it. It doesn't mean that you're going to save money using the prescription. You can still go to CVS and just pick it off the rack, but then it's in the record as medically necessary because you prescribed it by a medical professional. You know what you could do, Fun Scratcher, is if you are using it, let's say you're using even in your house, if you're zipping to the bathroom, maybe you don't use it if you're going from one chair to the one recliner to the other recliner in the living room because you're like, I can hold on to this and I just can't. But if you're using it all the time, like anytime you're outside the house and even sometimes in the house, it's not a bad thing to, make clear that I'm still using the rollator all the time like I started to. I was kind of hoping I'd be a little stronger now, Doc. Can we talk about how I might get more strength back to my legs at my next appointment? Like, should I have physical therapy, Doc? Sometimes you just gotta speak it to them. And that would be a message, by the way, Fun Scratcher. So it would be stuck in your record because it doesn't strike me as a tape that's gonna take time to put it in. Lily says, I applied 2020, last received survivors 2021. I'm sorry for the broken messages. That's my No, that's okay. I mean, you're on a chat board. It's not a problem at all. I expect that from the best of us, including myself. So you're still insured as you're not insured now, obviously. So if the case went south, you would be poop out of luck, right? Now you're getting survivors. Is your disability, I'm assuming your SSD is going to be far greater than what you get in survivors and it's going to replace it. If your survivors was more, might not be, the whole, worth the whole thing at this point. Except that you want that maybe that 1 year from 20 to 2021. I don't know. And if you applied in 2020, doesn't mean that was your alleged onset. It could have been 2019, 2018, something like that. Hey, Tracy's in the house. Hi, Tracy. Tracy hears ya. She says, hi there. Do you recommend to your clients to take an outline summary to CE exams? I'm getting mixed messages on that. I personally don't. I'm not necessarily saying it's going to hurt you. The doctor might take it, might not take it. If you're saying because you're not going to remember, you don't even know his questions. So usually the questions that he asks you are going to trigger your knowledge of yourself. So, all right, guys, no more barking, please. Sorry, I have the door open because of the air conditioning. So I don't think it'll hurt you one way or the other. It might look like I need notes because I don't know what to say. I need to be prepped for. Remember, it's a doctor appointment, not a treating doctor appointment, but it's, about, what you know to be so. So I don't know. I don't, because they're just going to ask you, you've seen the videos, right? The kind of things they ask. V is in the house. Hey, I haven't seen you in a while, have I? I hope you're doing okay. I'm turning 62 years young in September. I have SSI. Do I have to take my retirement then? Unfortunately, yes, because now you have insurance benefits that can cover part of your basic living needs. So the welfare program doesn't have to, the taxpayers don't have to pay that part because you have insurance that covers that you work for. So that's one of the negatives about SSI versus SSD. You'll be, if you have access to early retirement, you're going to have it accounted. If you just said, forget it, I already won the lottery, I don't need to do either. I'm going to go off SSI, not file early, wait till I'm 67 and get the full amount, or better yet, wait till 70 and get the far bigger amount. I think you could probably do that too, but I'm guessing that you can't afford to do that and didn't win the lottery. My husband just got his new school loan monthly bill. It's not pretty. They kind of put off everything since COVID, so they didn't look at new tax returns and stuff. So it's quite a hike. So not in the cheeriest of moods. I think he's still in shell shock and it's been like a week. Doesn't kick in until October, but still. Yeah, and because of that, I'm going to start putting together something about, I don't know if you guys have school loans, but just a little bit about what to do if you're disabled and want to see if you can discharge your school loans. I have that in the works. It's quite a long way through, but I have to just get into really proofing it and everything, and so that's going to take a while. But yeah, it was something I kind of jumped on. I'm like, how do you know? Like, people do ask about the school loans on here at times, and then privately, and I don't really have anything besides the general, like, oh yeah, go to the Department of Education's website and fill it out. But it'd be nice to know maybe a little bit more in advance that one can read. All right, so this was the consultation URL. Should she need that consultation? You never know. Maybe we have an opening in your category. While it stinks to have to switch attorneys, stinks for us actually the most. Sometimes we do it. If you're otherwise a case, we would be able to take because of the category. So something you can think about. I don't know what the category is though, so I don't want to say it too glibly. Hell, I don't know what your original question was. Oh, you were home about the consultation. That's funny. Okay. Yeah, I that's disappointing that they did that to you. That's not that, that's very common, unfortunately. But that's one of the most important things we do, actually. Work history report and function report. And it sounds silly, but it really is, because those things are what can sink your case. And for not just like discretionary reasons, but like the work history report, if you're over 50, it's very critical. It's super critical. Ringo says, well, our fathers are in Spokane. Oh, and other than Washington. Okay. 7 hours east. So you're not talking about the Canada fires. Multipliers since August 1st, most are still less than 15% contained. Is that because you have it so dry right now and it's your dry spell? Because like we were saying, you're saying it's drier than usual in terms of rain. Some intentionally set. Yeah, what are these pyromaniacs? Gosh, they should be in jail for life. Sorry. Look at that. Intentionally set. Comparisons to Palisades and Lioness. Yeah, I haven't been watching the news. Sorry. Not like the environmental news. In a few days, actually. I'm so sorry to hear that. I'm glad it's not near you, though, but I'm sorry for the people that it is near. And I know people in Spokane. Sunshine's in the house. Hi, Sunshine. I had my mental health CE in May, but still no determination. Yeah, we talked about this last week, right? Was that you? How long do you think for answering regarding initial application? I would have thought you would have had a determination by now, given that you had your CE and, but there must be, do you talk to your adjudicator? Are you self-representing? I would call that adjudicator and make sure, what are you waiting on? Am I missing anything I need to get you? Have you been, if you're pro se, have you been updating her on all of your visits as they go along? That's what I would be doing, at least maybe even weekly, if you have multiples. If you only have one that you go to, maybe it would be monthly. But Kathy Clayton said, on my approval letter, I noticed this sentence. The appeals council may review my decision within 60 days. That's standard language in everyone. So I wouldn't worry about it. It's a fact, but it's in every letter. Should I put the back pay money up until 60 days? You mean, should you not spend it? So rare. Technically, that's probably the most conservatively safe thing to do. But all the award letters, even after a judge, it's a hearing, they have that language in there. So if they reversed it on you somehow, you would just be having another hearing. And honestly, if they reverse the judge's award, the judge is going to go out of his way to make sure you get that award because he already knows what he thinks. He made the decision. The attorney advisor doesn't make the decision, by the way, but she does advise them, of course. All right. He already knows in his heart that you're disabled, and he found the evidence to support it in his opinion. If the appeals council were to turn that around, my strongest bet would be he's going to make sure you win regardless. Unless there's something wonky, he's going to now make because they would have remanded it and said, you didn't do this, this, or this, judge. You have to have another hearing. And then before you render this decision again, you make sure you covered that base. You're going to cover the base. It's probably going to go your way because, A, he's got pride. And B, I just think that's the way it's going to go. It's not the same when it's a denial. When it's a denial, they're not always dead set on repeating the denial to you when it gets kicked back to them. I've never had, I don't think, a remand not get awarded. So the judges are not, we all have egos and stuff, but I don't see them doing that, at least not in the 21 years or whatever it's been since I've been doing it. So, but that's not to say a lot of people don't get re-denied on remand, but I don't know if they do all the things that we do, like go balls to the wall, new evidence too, give him a reason to be able to change his mindset about whether he thinks you're disabled or not. Because now he can be pleasing AC and not showing, not eating crow by changing his decision. I know, it's just kind of a psychological thing I was thinking about. It may not be true. We'll have to ask Judge John. If he comes on. Come on, John. I don't know. I hope he's feeling well. DJ says, not really skilled. I am direct support, guy with disabilities, driving under 20 minutes, run errands, short walks. So were you like a handyman or someone's helper? Was that your career? Short walks, pain also exacerbates mental health issues, surely. I know that. Pain increases 2 to 3 hours, working 4 hours is rough. And you're 53. Yeah, don't give up. I think there's an avenue. Reach out to us. We can at least take a look, okay? If you want us to. Ciao. Hi, I'm new. It's my LTD disability insurance. Sent me to them. Oh my God. I always tell people, do not use the, they might withdraw without demanding a fee. If you win later. And so you might be able to escape them. Is this the ones that would help you with your function report and stuff, right? That's just, okay, I'm just going to be insulting, but I feel like that's just a group of non-professionals. They get paid, I believe, by the insurance company, whether you win or lose. So they have no skin in the game. Just take them home. And it's funny, the LTD, you would think the LTD, they want to make sure that you at least get a claim before the SSA because they save money. They pay you less if you win your Social Security. And I guess they figure you might go pro se and then have a bigger chance of losing if they don't send you to somebody that you'll be willing to take because they won't charge you. Maybe I think they do that, right? They're not on your 1696. They probably don't charge you to represent you, but look what you're getting. It's like they're just sitting in the papers. They're not doing anything. I don't know where they shovel it to if you have a hearing. Do they have a non-attorney, probably a non-attorney rep that doesn't know your case and just is the body there? I always say never, unless you know something special, don't ever use the group that your LTD sends you. They don't send you. You have the option to go wherever you want, but people don't necessarily know that. So they're like, okay. And then, then they see, there will be no fee to me if I win. That's usually what it says because they're going to get paid win, lose, or draw. They've got zero skin in the game. They don't need you to have a good function report. They don't need your work history report to be accurate and really reflect how hard your job was. You don't need it. They just need to get the mandatory paperwork in, good, better, ugly. My EF, is that ejection fraction for your ticker? Chronic heart failure, and there are no help. YouTube pushed you to me. Oh, well, that's nice YouTube did that. You're so helpful, freely advising. Oh, you're very kind. I'm thinking they're a lazy firm. You know what it is? It's just that's their business model. I find it unethical. I don't know why it's allowed to be. I mean, I would think that assistance with the paperwork is a minimum, Anyway, just my take. If you want us to look at it, shall just. And you said consultation, but it depends. If you want to, there's a playlist about the pros and cons of terminating your representative. In your case, you might not have a lot of the cons because look at your 1696. If it says that you're not getting charged, and you can actually call them, they're often very nice about being like, oh yeah, we'll withdraw, or we'll send in a withdrawal, which you could also send one in. But when they do it, you want them to say, if your 1696 said they'd be getting a fee, I think it probably says they would not be, but double check. Then you shouldn't have a problem getting a new representative because there's no mandatory fee split. If you had someone who had, in the regular, like our paperwork, we're going to collect a fee, and then you part company, that first attorney or non-attorney rep can do a fee petition if and when you win and say, this is what I did, so yes, I would like this fee. And then the SSA decides what they're going to approve with regard to that and any subsequent person you bring on board. So, but if the first person was waiving fee anyway, it doesn't matter. Or getting paid from a third party like they probably are with the LTD. But if you're going to do that, I suggest you do it now. It sounds like you're on initial, right? I mean, you could be on recon doing another function report, but I'm guessing it's your first function report. Start moving now. Check that 1696. Do they have a hook into a fee? If they don't, I mean, you can get rid of them anyway. Just know that you're going to have a harder time getting a representative because they have to consider how much work they have to put in to get, like, at best, 50% of the fee. At best. Doing all the work. So, I mean, you probably know everyone works on tighter margins in this field. It's by law. So that's why you have to be good to be able to stick it out for a long time. Fun Scratcher says, left leg gets very weak. So yeah, I mean, it sounds like you're still weak with the walker, and that's something maybe you could mention to your doctor. Just be like, the walker is a savior. My left leg still buckles with it, but at least I got my arms to catch me. So when I go to the floor, I don't go hard or it gives me, it gets weak and then I can slide it over to the couch really quick and then I can sit. Just an idea. Whatever the accurate way it happens with you is, that's what I would share to him briefly. Rocha says, I don't have an attorney, Stephanie, but I had applied since 2021 for SSDI. I thought you said 2020. Oh, in 2012 for SSDI. 12. He asked for updates for 25, 26, already uploaded medicals for new PCP. I had a full hearing. What is your DLI, Lily? Did we talk about this before? I know you and I have chatted on here a bit, but because you're so nice. But I'm wondering what your date last insured is. I mean, if you're filing for SSI in 2012, does that mean SSI is a deemed application for SSD? So did you, for some reason, not have insured status, but then you started working after 2012, became insured, and then you could file for SSDI? Curious about the work history. Kevin Johnson says, law firm I had is the state where your sister lives. Premier out in Minnesota. Is that a law firm? Or is that a advocacy firm? I don't know. It could be a law firm. LaRocha says, he might request a second hearing, is what he said. Just in case I missed anything, I wanted to tell him. But I'm good with his best judgment on my disability case. They don't usually, did you go through a full hearing where he asked you questions about your functional limitations and stuff? Or was it that very beginning you said, hey, listen, if you, I'm curious about how that went down. You want to know why I'm not driving much anymore? LJ was a sweetheart, by the way. Yeah, they usually are. I very rarely, I think 2 or 3 times in 21 years have I come across a sourpuss, meanie judge. And the irony, right, it's going to sound bad. The 2 times I can think of, and I just assume there's got to be another one. It was both women. I hate to say that, but it was true. And both white people were awarded, nonetheless. But yeah, so, and one was a woman client. She was brought to tears by the judge. It was not very nice and very droll and just crap. Not a good ambassador to the SSA. And then the other one was a male client and a grumpy arse judge. This is in Pennsylvania. Well, one was New York State, upstate, like Binghamton area. And one was, and both are quite a few years ago now. I don't see that a lot. I just think the judges, I mean, even if this is not because I win a lot, even on the horrible but rare occasion we lose, they're still nice, they're just doing their job as best they can. And they're stuck with rules that they don't have the power to change. Hey, Baxter. Good to see you. He says, hey, Steph. Rocha says, my DLI is throughout. No. Is throughout. I'm 60. No. I believe it's what I understood. No. Your DLI is a set date. Yeah, it's a set date, but you don't have your decision. If you wanted me to figure out your DLI, I could do it, Rocha. Give me like a redacted, the earnings statement that covers at least until you stopped working, earning in any way. And we could chart that out for you. I'm just curious because your dates seem weird to me. And that will affect a lot. Slot sisters. I was told nice to meet you guys. I was told I actually meet listings and equal them. Hopefully the ALJ see it the same way. Oh, someone else told you that, but that doesn't mean, like, who told you that? Your grandma or, I'm just kidding. But was it like your lawyer maybe? That they believe you meet the listing. That's important. I think, that's a strong, if it's an educated person, if not someone just shooting their mouth off, that's a strong indicia that you have a good chance of meeting a listing. Be surprised. It's weird how, a judge will see something differently, but listings are good. Baxter says 3,000 milligrams Keppra, 400 milligrams Keppra. Norco 10 twice daily. And I don't know how it could hurt. That's a lot. That seems like a lot to me. I imagine I'd be in La La Land, but I don't know. What do you think? It will help your SSDI case if you have symptoms that stem from them. Do they make you sleep half the day? Do they make you groggy, stupid, can't operate machinery, can't drive, don't use the stove? What do they do to you? And what is it that you're trying to prove? Do you have to prove that you can't do a brainiac job? That might help. Like, were you a brain surgeon before? You were the EMT guy, right? Very good one, if I recall. Right, Baxter? Was that you? I would definitely think this stuff would prevent the prior work. So depending on what kind of case you have, how relevant that prior work is in terms of being definitive. If you're a grid case or you're younger than that, it would be different. But that would definitely, I would think that would be affecting your mental acuities, the side effects. Patricia's in the house. Patricia, I don't think we've met, right? Hi from Florida. Nice to meet you. My mom used to live in Florida. I used to visit it all the time. Been watching for a while, but first time joining chat. Oh, I'm glad to see you. So glad you joined. It's always good to hear a new hello. Otherwise, we have no idea who's here, right? I applied for SSDI 5 months ago and just got approval. Woo! That's awesome. Good for you, Patricia. I'm very happy for you. Yeah. See, guys, there is a light at the end of the tunnel. But make sure you're steering your ship through that tunnel, because if you go around it and then your DLI passes, there's so much, I know, there's so much. Baxter says, neuropsych notes, I would be off task 20% of the day and miss more than 5 days per month. I can't say whether the ALJ accept it because I'm not the ALJ. Did the neuropsych notes, are they well supported by other notes that kind of hint at the same thing? Or is it out of the blue? Who says this? Is this the neuropsych that you paid for his opinion? Or was it an objective guide? It's not, doesn't have a conflict. The most important part is not that latter, it's whether it's well supported by the other very robust treatment records. Someone that would, whatever, neuropsych, just, well, yeah, you don't know, will he accept that as being gospel? Well, is there other things that say otherwise? You see what I'm saying? It's the totality of all the evidence as to whether or not that's considered like reliable and most likely to be true and all that. Because if it's, you know, if you're that bad off, you would presumably your other providers would have it very vigorously noted in their records. I would like to think so. I know I'm being a little bit facetious here, but that's because they don't do these things. And it irks me to no end. It's like they have the power, if they're articulate and only saying what's true in their mind. But a lot of times they don't articulate it. It's just not part of their treatment protocol. But I want them to know, like, yeah, but your client, life has so many other things, and you know this is an obvious one, because if you, Mr. Doctor, became disabled, you too would be filing. So it's something that we all have because we all worked, you know, for the SSD anyway. DJ says, we're at 2:40, guys. We got another 20 minutes. He states, I could be a routing clerk or a storage rental facility clerk. I can't sit over 45 minutes or stand much over 35, sometimes less. Okay, so I can pick up one thing now that you might have left out, besides IBS issues, anxiety, etc. Okay, you can't sit more than 45 minutes without needing to change position, and you can't stand much over 35. So now if they found that to be very clear from the medical records, they could still deny you, because I'm guessing that the routing clerk and the storage rental facility clerk could sit or stand to do their job, you know, every half hour, switch up. And that would cover that problem. So that, you know, what we try to show when someone has a problem like that, usually it's like the back or the knees or a combination thereof, is they can't do upright positions, work positions, which are standing, sitting, or walking. They can't do, even if they rotate those positions, they can't last 8 hours. The back is going to hurt just by holding up, or it could be the neck, shoulder, just by holding up the body. They can do maybe 4 hours, and I think this is what you're alluding to, right, DJ? And that's all they can do. So that's what, now they said, did he say that you, so he said you could do light work. I wonder if it was a sit-stand option. I'm thinking that rental facility clerk might be a sit-stand option job. And you didn't have evidence that your evidence is that you can't sit over 45 minutes without changing position, or stand much over 35 without changing position. Well, good. A sit-stand option job means you can change up and down when you want, and then those jobs are available. So that's that little crack that may have been left. We didn't have it covered. And it's not easy to cover, particularly when doctors don't speak to these things. And also, like you said, won't do, or someone said here, won't fill out the RFCs. Just a little add-on for that, guys, as you've heard me say before, but for anybody new here today. Sometimes the amount of time you have to, like now that you're not working because you're filing, you're not working full-time. On a day you're not working part-time even, do you find that you have to go get out of the sit and stand walk position and go into the recliner? Does it amount to a few hours during the 8-hour period, like 9 to 5? Like you do up and about, do a little gentle things around the house, then you have to go sit down in the recliner, because that's not a sit-up position, that's work related. That's, you know, lying back, or it could be on a couch, lying down, or in bed. If you find that throughout your day you've got to do that, I would journal it just so you always know how often you do it. And that's something I would also talk to my doctor about. Like, I can't even, you know, I have to keep going to rest all throughout the day. And then hopefully they'll start getting the records that way too. The pain starts growing in my back, and I can alleviate it if I go, you know, lie in the recliner for about 45. Then I can get up and do, you know, probably I can pull out another hour and a, you know, hour or hour and a half. But by then it'll elevate again, and then I have to go. Because otherwise, I just won't be able to make it through the whole day. I'll be useless when my kids come home from school, because I was on my feet from 8 to 3 or whatever. Baxter says, SSA Psych stated my cognitive issues are related to my seizure disorder. The seizure disorder is medicine resistant to 2 seizure meds. Well, if it's a seizure disorder, like an epilepsy, if you have them provably so frequently that it would negate being able to do a job, if you have one every 6 months, it's probably not going to do the trick. But let's say you had them a few times a week, or maybe even monthly. There is a listing for that. I just don't know the details. Listings are just always going. Read them when they come up because you never know if they're going to change in between. And but I mean, resistant. So the seizure meds are not working. I assume was your driver's license pulled? Because that's what the doctor's supposed to do. If you have a driver's license and you're having seizures, because it's not a really good combination. A lot of doctors are hesitant to pull them because people will get upset. But I think technically they're supposed to. It's a medical, I don't know if you call it a medical suspension or medical revocation. I forget what the word is. And it's just until your meds, provably you have to have gone a certain amount of time without a seizure. I know it's not easy, Baxter. DJ Kenny says direct support professional. It's taking mentally disabled folks on errands. That's you. You're a direct support professional. Okay. It's taking mentally disabled folks on errands, socializing. I used to work in retail at bike shops for 15 years before I was at bike shop. That's pretty cool. All right. So basically you're like a nurse's aide or a companion aide for the mentally disabled folks. You're doing that now, DJ? Isn't that a physically arduous job? Or are you only driving? Do you have to help them in and out the thing? Do you have to make sure they're in someone's hands safely? Do you walk with them in the store? I mean, if they suddenly freak out, you're expected to contain them, right? I could see that job being contrary to some things. I don't know if that's if that's your job, but if it was, I think that could be problematic. And I'm not saying you could do it 8 hours a day. I think it's a very hard job, actually. But the fact that you do a very hard job, despite your even part-time, it might speak to it somewhat. I don't know. That's just my thoughts on that. And again, I'm just surmising what the job entails. And you take them. You're able to obviously go out in the community. Your anxiety is not so high that you can't negotiate the community. Not agoraphobic. I could understand perhaps the judge being on the fence and going the way he did. If what I'm just kind of speculating might be something about the current job. And the prior work was a bike set. And the prior work, I assume that's not your work in the last 5 years. Baxter says LTD want their premium covered money back if you win your SSDI case. No. Premium? No. No. If they have determined your contract, which they probably do, they don't necessarily get everything they paid you. If that term says when you start getting SSD, first of all, under the terms of the agreement, you agree to file for SSD. If you don't file for SSD, we can stop paying you. And then if you win your SSD, if we were paying you $4,000 and your SSD is $2,000, we get to drop ours to $2,000. So you're still getting $4,000 between the two, $4,000, but you're not getting the $2,000 plus the $4,000. So they get to reduce theirs by the amount of the SSD. I had done a video a long time ago. It was a series of them. It was about bad reasons to not file. And one of them was some people said, I get LTD. I'm not going to bother filing for SSD because they're just going to take most of it or potentially all of it or whatever. And I'm like, yeah, but number one, you don't get Medicare. And number two, by not filing for SSD and not being found disabled, all the 0 years of work you have now up until 62 are all zeros. They're going to count and bring down your benefits. So when you do retire, expect it to be down here, not what you saw in your last estimate statement. So I would never, ever, ever suggest not filing for SSD because you are getting LTD, even if there's going to be that offset. And most employer policies have the offset nowadays. It wasn't like that, a few decades ago. Then you could just plug them both. And it's not a law, it's a contractual thing. You could buy a policy that doesn't do that. You're going to pay more for it, obviously. Tonino's in the house. Hi, Tonino. Love your flag as always. What do you think about companies that help you with the disability process, such as Claimify? I wouldn't know because I don't know Claimify. Is that new? There's just a ton of them. It depends what they do, like helping you with the disability process. Are they filing paperwork? You just heard shall. Are they getting your information and typing up the function report for you so you don't have to do it based on the information you give them? Are they doing the analysis on your work history report and then creating that with you? You know what I'm saying? I don't know what they do. Do they have a portal where you can update them in real time as you have doctor's appointments and get new doctors and have repeat visits and all that so that they can communicate to the adjudicator in the middle of any given week? I don't know what they do. I suspect, I don't know what they do. I will say the majority of companies whatsoever, even law firms, because they're not getting paid by the hour and because you have to make more than you spend on running the business, the practice. For it to be viable, you have to make enough to support yourself after paying your people and all that. So no one wants to, put unnecessary time into, well, for some, into any task, they can not get in trouble for saying we don't do that. We don't have the resources. You'll have to do it yourself, even though you're our client. And there's a lot of stuff the client should be doing themselves, for sure. But that's loud. Just close that door. Did you guys hear that? Okay. So, I mean, it's just and I know there's others like me. We're just maybe the minority that think no paper goes in without coming to us and being reviewed, and or usually if it's a form drafted by us with all the claimants, all the data that we've gathered from you. Just because the way you word it can tell a story. Sometimes most of the time, there's going to be unresponsive answers in there that don't even address the question that's being asked. And other times they misinterpret the question. They don't add something that would have mitigated how bad what they had to say, blanket wise, mitigated that by explaining the qualifications behind it. All those kind of things. So I can't speak to it. Are they attorneys? Are they non-attorneys? Non-attorney reps can be very, very good. I have colleagues who are really, really, really good. And some can be bad. And the same is true with lawyers. So, because a lot of lawyers do the same thing as some of the big box, advocate groups. Like, I don't know if this one is one. And it's a numbers game. They take in as many cases as they can, let them roll out. Don't do all the bells and whistles. Hey, 50% won out. We just made $10 million and 50% loss, which is a horrible rate of loss. I mean, that's I don't know. I find it unethical, but I don't know what every outfit does. I have no idea. I just know some are like that. So you really need to ask them if they say, we don't help you with that, and we don't, well, then that's your decision about whether you think, is that fine? Is that okay for you? Dio. Well, what does that mean? What does that mean, Dio? 30 jewels flower. That's sweet. Is that a gift? Or is that something you won because you're such a great participant? I'm sorry. I don't know much about this, the ins and outs of the YouTube workings. But it's good to see you, Dio. DJ said, I work merely 4 hours, 2 days a week. I let them know I know it's not a lot of hours, but think about what you're doing. I let them know my employer offered a third day and I knew I couldn't physically handle it. I need rest. Okay, and guess what? The guy didn't believe you. I mean, they never use the word credibility anymore. They were banned from using that a few years ago. He didn't find what you say to be entirely consistent with the medical record, all right? Or well supported by the medical record. Maybe is a better way to put it. And if that's an arduous job that you're opting to do 8 hours instead of the more sedentary type of easier job, that might be why. And I know that hurts your feelings because it sounds like you like what you do, and it sounds like what you do is really important and stuff. But and again, I know what you're saying. You mustered out this way. You're probably very uncomfortable after a 4-hour shift too, is my guess. I get it, but you just have to be smart about what the jobs that you pick. It's not just keeping the hours down. I'm really sorry, Teach. Patricia says, to add, I'm 60 years young, right, Patricia, with cerebral atrophy and cognitive decline. First application, I didn't get a lawyer. I just made sure I gave them every doctor visit notes, MRI, and neuropsych assessment. Yeah, and I'm so glad you won. Thanks for all your wisdom and advice. You are very welcome. It is always my pleasure and my privilege. Salt sisters. I was also prescribed a rollator walker by my rheumatologist after I fell out of the shower. Oh my gosh, I hope you weren't hurt. Oh my God, you chipped your tooth. Nope, Chat GPT told me. Told you what? I uploaded my records to Chat. You want to make sure you have I don't know if it's a paid for account you have to do this for or not, but make sure they're not using your medical records to train upon. I mean, not that what's the chance of them carrying that it's you, but that's a public place if you're not paying for a private, protections. Just do your due diligence if it matters. And again, I hope they're planning on screaming out your social to people. MRI showed nerve impingement on my L5 S1 bilaterally. Ooh, nerve impingement. That is a good finding. Not good for you, unfortunately. I'm sorry, but it's very. It supports why someone would have pain. Therefore, it supports that they do have the pain, significant pain. Slot Sisters also says severe fibromyalgia, chronic pain syndrome, chronic spondylosis, neuropathy, chronic fatigue, agoraphobia, major depression, panic disorder, generalized anxiety, Hashimoto's, morbid obesity. You got a lot of goods there, sister. That's a lot. Tick is in the house. Hi, Dad. Just kidding. It's good to see you. I haven't seen you in a while. MRIs are good evidence. That's what I say. And I'm always pushing my clients, and some of them try to ignore it, and then it's coming up to here. I'm like, did you get it? You didn't get those MRIs. That can be helpful. Some I would push more than others because some it may not be the hinging factor on our case, but MRIs show a lot more than X-rays for many, many things, particularly those kind of nerve impingements that Slot Sisters talking about. One issue with MRIs, guys, and this has been going on for decades, because even before I did this kind of work, and I'm in my third now, or a decade, it was, I was always reading about MRIs, we lie down for our MRIs generally. But sometimes, think about it, gravity's effect on the spine when you're standing up, compression, that's relieved when we lie down. So I think lay down MRIs don't show all the damage for a lot of people. And it comes up being very mildly whatever, and not the nerve impingement or whatever. If you can get a stand-up MRI, that's what I would be doing if that was me. There are not that many of them, and the companies are too cheap to like trade out their lay-down ones for stand-up, I guess. But it irks me, because I think it gives false evidence then of what's going on with those discs. And I remember a doctor talking about it, and I've just never forgotten it. So it must have been on some sort of video a long time ago. But I was like, oh my gosh, people are going to these lay-down MRIs, and it's got to be where it's impinging on it when you lie down. Like, that's got to be the way those angles go. But I think a lot of time, gravity is the thing that, starts to hurt it as you're standing too long, walking, even sitting too long, because your gravity's, pulling your body down on those discs. I don't know, just a little aside there on the MRI business, guys. Get a stand-up one if you have a bad back. If it's a leg or something, it's not gonna matter. Slot Sister says can't sit for longer than 20 to 25 minutes without needing to lie down. Yeah, if you've been treating for all these things consistently, regularly, each and everything, preferably with a specialist. Some of those might be treated all by the same specialist. You probably can have a good case depending on your vocational profile again, but basically your age and your prior work. But that would be some of the stronger stuff there. Shell says, she's talking to Patricia. I don't want to interrupt that. DJ says the mixing of sitting and standing definitely won't help when pain is bad. I get it. That's probably what you were lacking it was the choice of having a very arduous job that you also have to focus very strongly on. You're like a caretaker to these people that can't take care of themselves. It's a huge responsibility that you're doing for, 8 hours a week? So I'm just saying, I think that's probably what had to do with it. I fully believe you can't work full time. Certainly not at that job, but I don't have any reason to think you could do even a sedentary job full time because of the sitting. However, if you could have proven that your physical problems were enough that you could sit down for 8 hours. Might not feel great, but you could do it. But I can't do the on my feet 6 hours, and that you weren't able to do that. The judge, I'm educating guess here, based on the law that applied to you, was that he found you could do light work, right? Heather's in the house. In Maryland, I was told it was my responsibility to report my seizures to MVA for driving restrictions. Kind of scary. It's up to the driver when we have blind 90-year-olds refusing to give them up. Oh, yeah. I remember when I didn't want my mom driving anymore. She's not blind, and she wasn't 90 either. Well, here's what I think about that. You have the power not to drive. So why should you be responsible for having it taken away? Just don't drive. If you were to be found driving and you get in an accident due to a seizure, I think it could be reckless. It could be a murder charge of sorts. It might be more than involuntary manslaughter, because you knew you were doing an activity that could very likely kill somebody, and you chose to do it anyway. That's, so, people just shouldn't, they have to think about what they're claiming their problem is. And if they're out there driving, no one's going to believe them. A judge shouldn't believe them. Because if if someone is that risky of a driver, they're not going to be hopping behind the wheel. If it's the kind of thing where someone gets auras 4 hours before they're going to have a seizure, so they know it's going to be coming this afternoon, let me get my errand done now, because it doesn't happen. It's a very slow, you have a good window of, that could be different. And you'd want that definitely documented so that you could prove why you feel it's okay for you to drive. For an SSD case. I'm not talking about anything else. Heather says, my grandma's blind 98-year-old friend just finally turned her license in a couple months ago. She swore she could see better in the car than walking to the mailbox. They're so funny. It's not all just the vision too, Heather. It's like your reflexes are slower. You're noticing things are different. It's definitely, by the way, we're after the 2-hour mark, guys, so I'm going to wrap it up as soon as I can. It's definitely not just vision, right? My grandmother that died at 95, my understanding, I was told, was she had just driven to the store to the mall. I guess that day, she might have died in bed later or the next morning or something. And she had gone to the mall and I guess shopped, and I drove herself. So the driving didn't really kill her, but old age did. DJ says, I'm a companion. I don't do anything but drive. Well, you said you socialize and take them on errands. Who takes them out of the car? You have someone with them. I don't take any clients with higher needs. No lifting, no helping someone up. It's driving, walking, sitting, short periods. Best option I found. There are more gentle things than that, but I understand what you're saying. What? So is there, do they have an actual babysitter if you're just the driver? Who is responsible for them? Should they go, they're mental patients, right? If they have a meltdown and start flailing out at people, who's to get them under control? It better be somebody else, right? And if there was, I would have had that explained. But I'm just saying, I think that might have been the issue. Because think of the impression I had from that job when you described it. It was pretty arduous. I mean, if someone falls, you're not going to help them up. Are you saying you're just going to be like, we're not leaving till you can get up off that floor. I see you got a broken ankle, but that don't matter. I'm not help. You know what I mean? Like, well, who was in charge of them if you were just the driver? Which I believe you could just be the driver. There are people that just drive the vans and stuff. So I'm just wondering about that. Alleging, does any of this info cover SSI? Only if you ask about it. We only answer what people are asking about. This is not it's not one of the daytime ones where the title kind of tells you what's going to be in it. So you have a question, alleged, just go ahead and ask it. It might have to be, might have to be next week, but we are pretty much hoping to get there. That's a private conversation. Okay, DJ says we get coffee in a shop, a 15-minute nature walk. So 15 minutes is usually 3/4 of a mile for just a regular walk, not a speed walk. So you can walk that, but probably you go halfway and then halfway back, right? 3/4 total. And lunch, sometimes he buys a few things at grocery store or handled by him, carrying items. Might go to the night too. Are you just dealing with one person at a time? Not like a bunch of them? Sounds like it's just one person. I wonder if the job was described as companion for a high functioning, low needs. I'm just wondering how your work history report was. It made that clear because if we said the way it sounded to me, could be pretty arduous. Like I'm assuming, okay, he's mental, but he's not like one that freaks out and runs down the street and you got to go running after him. And he's not physically impaired, so you don't have to worry about him getting weak and falling down or being in a wheelchair and falling out of it or anything like that. Slot Sister says about the meeting, the listings. Praying for fully favorable approval. Absolutely. I'll be praying for you. Onset date, February 15th, 2023, and I have arthritis in my facet joints on top of a vertebrae that slipped backwards. And then you probably have arthritis in other joints, so don't forget to treat for all the other body parts that are not 100%. And are not like they were when you were a strapping 20. Slot Sisters seen in the ER, primary orthopedic, pain management, psychiatrist, therapist, rheumatologist, and neurologist. We got a good set of doctors, so that's good. We did 2 different physical therapy offices. Old CE said I was marking on a couple things. Ooh, that's helpful. But then you got denied because it's an old CE, I guess. DJ says, I let the judge know my job. I was working a month. Well, yeah, but if it conflicts with what you said before in your work history report, that's the problem. And that is exactly why work history reports have to be done perfectly. And when they're done, you want to know what law you're following and tailor your accurate answers accordingly. Don't leave out the things that would have shown, right? You're not fabricating anything. It's just that you can't describe every single thing you do in a job on a work history report. So people take out some broad ones, but they pick the ones that don't show what would be needed to be shown. DJ also said he was working a month. When I tried to return to work over 5 hours a day, accommodated need to sit at counter instead of standing, couldn't do it, sit or stand on periods. I hear you, but the medical evidence, you have to have all that evidence. I know it's very frustrating. Dick says, hi, Stephanie. Knowing your pain levels throughout the day helps a lot, too. Slot Sisters cuts through a lot of storytelling. Knowing your pain levels. Meaning like avoid pain, avoid activities during the day. Are you saying, Dick, about, so you don't aggravate it, maybe? Dick says, I was lucky enough that my neurologist ordered a new MRI at the same time they were doing a review. So I had a fresh MRI to look at. Yeah, and guys, sometimes you can push for it. I mean, if you had one 6 months ago, maybe not. But if it's been like a year and a half, I mean, I kind of want them every year, but I know sometimes insurance can be difficult. Then it's going to be 2 years. But if it's been, to me, I'm like, start pushing at the year, and say, it still hurts. I want to see what's going on with it now. That was a year ago. And those kind of things are almost always degenerative. Whether it was caused by something not degenerative, like an impact or an acute injury, it could be workers' comp, it could be a car accident, it could be you fell in your in your house. It doesn't really matter. But degeneration still happens. It doesn't, eliminate that. So just because you haven't been hurt again doesn't mean that MRI didn't change, and it probably did. Agree or disagree? Baxter says 2016 amnesia. It's in my medical record, and memory loss is in my record for the last 10 years. SSA psychologist stated difficulty with rote tasks. That's very strong. And adaptability is the neuropsych 20% off task. Valid. So the SSA psychologist, if that's different than the neuropsych, and they both agree on some really things that, if believed, would be disabling, having both of them say it is exponentially better than just one, each one separately. It's like you got two people that are experts saying the same thing. Yeah, one you paid him, but the other one you didn't. The SSA is actually paid by the SSA. DJ says, I'm definitely losing my voice, guys. I'm not really sure what to do. Other jobs require either sitting or standing too much, or I'm with just one person. I am just one person. Have you gone to a state or county agency that places people with disabilities in jobs that they can hopefully do that are very part-time and genteel? Just something to think about if you haven't looked there, and it might just be that, I don't know. And it's not necessarily that you can't be doing this current job, but there was something about it that was lacking to get you down to sedentary by the judge, and that seemingly more arduous job. Now, if the job is, next time described a little better, like never ever, no lifting, no this, no that. It's merely companion. Like I would be driving that point home. Baxter says, thanks for what you're doing for us, Steph. You're welcome, Baxter. Thank you for your support. DJ says he has a rare disorder. He can't get full from eating. Is it called Prader-Willis? I have to make sure he eats his arranged meal and his meds keep. Well, you're only 8 hours a week, so you obviously can't help him the rest of the days. So somebody else is doing it. You're only responsible for making sure he eats his meal when you're with him, right? Because that would be one person doing that. That's quite a mental task of keeping someone else's basic survival needs, So his meds keep his anxiety at bay, so he's well behaved. Dick says they have that 1 to 10 system. Some doctors, it helped in my hearing. Meaning like you knew what so you weren't like doing guesswork when you were, every time you went to the doctor and you had to check it off. Is that what you're saying? Like, yeah, because when people are thinking off the cuff, they might be thinking about the moment that they're in. Their pain is low at that moment, and they do it low when, you hope the doctor's asking about, generally speaking, how is your pain, right? Not just like in this little snapshot when you just took your, Vicodin for your doctor appointment so that you wouldn't be in too much pain. BJ says his eating has never been an issue. I suppose if things got too difficult, I quit. It's rough financially to not work at all. I know. I just think, and I'm just so sorry the way it went down. And your attorney said they won't even do the appeals council appeal, if that's what you want to do versus reapplying right now. Reach out to us. I've done appeals council appeals on cases that I did not represent because that's what the person wanted, with the understanding, of course, that, if it goes back to hearing, we'd represent them on the hearing. If it gets denied, they could try to secure a FDC attorney, which I don't do. And then at the same time, we would file for the new period, so they'd have both periods covered. That's always a possibility. But I'm just so sorry you're put in that position that it's not over. And I know it's hard to get by on the money. But Baxter says, sorry, I'm jumping here. I didn't pay for neuropsych eval on my own. I was referred by my neuro. So it was just like he wanted to know, and your insurance covered it, right? All right, that's better. And sometimes people go out and get their own evals, Baxter, and it's like, or they'll be like, and it'll be a letter from the lawyers. It's so stupid. To the doctor going, hey, please examine, my client paid you, so please examine him and blah, 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 blah. I understand you're going to be examining him for disability. I don't know. It just gets a little, but it doesn't sound like that was you because you were actually referred medically for this. That's good. So it sounds, Baxter, like you got two specialists. The SSA paid one that seemed favorable, it sounds like you're saying, and the one through that you were sent to as a specialist by your own neurologist. And they seem to confer. So that seems really strong to the extent of what they cover. I don't know if that would make you disabled or not, because I don't recall all of your vocational profile to remember what the laws were that you had to meet. That's the disorder. Yes. I'm not sure which disorder we're talking about. Yeah. All right, guys, that was the last of our questions. So, and we are way over time, of course, as typical. I hope you guys are doing great. I hope you have a great rest of your week. This replay will the live is out there, but the replay that gets cut down will probably be putting them out on Sundays. So it'll probably be a week from Sunday. I was doing them rather immediately thereafter, but it put me on a timeline so cramped that if something occurred during the week, I was like, this had to get there. So that will probably, I think it's always going to be like 10 days later. And then at some point, the clips will come out. you know, so like a clip of something that was in here that we've talked about in another video, and I'll attach it, or I'll actually do another video to flesh it out more and give more of the technicals or something, just more information on that particular topic. So it's not just the whole replay necessarily. That's the only thing available. So people can just, you know, pick on the ones that they want. All right, I'm going to grab these last few pop-ins. DJ says they won't do appeals counsel. There's something showing up that there's some showing up that do appeals. Not sticking with me is stressful. It's not impression I've had they wouldn't stick to appeals if denied. Yeah, I don't know. An AC appeal is so easy. It's so easy. I don't know why they wouldn't do it either, but yeah. So we do them. So if you want to reach out, just feel free. I mean, AC has a lower chance of prevailing than other things. I think it's like 15% chance of a remand is it's always been kind of consistent over the years. So you don't want to hang your hat on it, and just know that you have to wait to reapply while the appeals council review is pending. Can't reapply until after it's done. But if you do some quickly, and you know, after you get a result, that if you get it that you don't like it, you can have a protective filing date back to the date when you actually filed for the appeals council review, so you don't miss all that time, because they can be slow as dung. I've had cases where they were 18 months. I have some right now. I think I have 2 that they're probably 6 months out. Oh no, more than that. Probably. Yeah, it might be like 8-9 months, and you just gotta wait. If you don't have a DLI that can allow you to refile again for SSD, then you have no choice but to wait. But if you can refile again and you don't want to wait, I think it really depends on, you know, the priorities and the case generally. Heather says, have a great evening, Stephanie and Tasha. I always get distracted watching her, but she's hiding today. Yeah, she's sleeping. I gave her a couple of snackies before we started. Vic says, later, everybody. Good luck. You too. Thanks for popping in. I appreciate it. Prager Willies. I thought it was Predator Willies. Yeah, isn't it like Predator? I knew a lady once that worked. Maybe she did what you did. I don't know. This is going back a long time. This is before I even did Social Security disability work. And I thought it was Predator Willies. Yeah, like you have to lock up all the cabinets, or they'll just eat 24/7, right? And therefore they're usually overweight, and they probably get diabetes early, and they obviously have severe cognitive difficulties. Wow, and you say he stays pretty calm, so that's pretty cool. You too. Thank you for your time and help. You as well. Thank you for being here. I appreciate it, guys. All right, so we're gonna take this to the curb. I'm gonna get myself another beverage, and maybe some lunch. But thanks for coming in, guys. If you have any questions, remember always you can put them under any video, and I will see them all, and I will get to them. Just maybe not same day. Sometimes that's hit or miss. Sometimes it's like a week later, and I apologize, but I will answer them. And I keep saying, and if it's appropriate, I'm going to do a video. It's just been so busy. Work has been crazy. Lots of interesting things, SSD wise, and of course other areas that I touched on out of pure love of it and all that stuff. So I'm just helping in those other areas. So it's been a little busy, but I want to get some of those in as well. I will talk to you guys soon. Have a great week. Be safe. And I hope to see you next Wednesday live at 1 p.m. Bye, guys.